I think I've discovered exactly where the issue happens in New Brunswick, where women are most susceptible in domestic violence situations to be in all provinces except 2. If a charge is to be laid, it is automatically laid. It is taken seriously, it is done, it is laid. And I'm not saying that police officers take criminal allegations seriously. I am saying that if the charges are confirmed by the officers, they are immediately laid. And when charges are laid, that is when protections are put in place for victims of violence, including domestic violence, to be able to protect them from the perpetrator of violence, whether we do a full arrest or just an undertaking with a summons. However, in New Brunswick, and if I'm not mistaken, in BC, I could be wrong if that's the other province, but there is something called the pre-charge screening. The pre-charge screening makes it so that any charge that a police officer wants to put in place, it has to first go through the Crown Prosecutor's office before making it into a courtroom. The reason being is there's something called Jordan's limitation, I believe it's called, or the word is slipping my mind right now, but where they only have like up to 18 months for charges, although with the new legislation, they have now extended beyond that for violent crimes. But up until recently, you only had these 18 months from the point a person is charged until they get their fair hearing. Anything that went over that would be stayed, meaning that charges would be dropped and everything would be canceled, and you wouldn't be able to recharge the person because they've already been charged. They've already had a hearing opportunity and it didn't make it to court in time. Where New Brunswick has a major backlog and where they're trying to make sure that they aren't wasting money in the courtrooms, they have implemented something called the pre-charge screening, where the Crown Prosecution goes into the package issued by the police. So whether that is a regular unit or regular officer or a vulnerable people's unit, which should be the one that you are referred to if you are dealing with domestic violence. If you are not, you need to keep pushing until you are. And I know it's a pain in the butt, but that's what you have to do because they're the only ones qualified to assess the violence that you're a victim of. Based on their assessment of this file, they decide whether to proceed with charges or not to proceed with charges. He said, she said situations tend to be a little bit more difficult. However, if all you have is your testimony and you are the victim of domestic violence, they still look at the pattern of your testimony. And if you have a pretty detailed description with a lot of facts and a lot of corroborating evidence, like you went and told your therapist about it right after, or you told his friend right after, so on and so forth, that counts as corroborating evidence. That works in your favor. It's not just a he said, she said anymore. And in the case of violent crimes like SA, your testimony is not considered a he said, she said. Because at this point, they need to prove that your testimony is not true, as opposed to validating your testimony. And with new legislature of the Protecting Victims Act, cross-examination is no longer allowed to victim shame. Whether or not they will is a whole other story, because we all know that the courtrooms are still not up to date with legislature passed in like 2016 and 2012. But hey, we're still trying. But where there's that gap is in that entire time that the file is with the Crown Prosecutor's office. And if your file is complex, meaning the SA didn't happen yesterday, or it didn't have pictures, or you didn't get hit and called the cops right away, that is where it goes into longer than the regular, I think, 2-week period that they're supposed to get it to the Crown Prosecution and get it through. So complex and historic cases where it's over a long period of time, multiple forms of abuse and etc. During that time, there are no protections. And if things escalate and you apply for an EIO, which is an emergency intervention order, that's your only option. And then it gets denied. Because in New Brunswick, even though they put the emergency intervention order for situations like this, because too many perpetrators of violence use the excuse of parental alienation, even though we know that the weaponization of children is abuse, And that is not parental alienation in that case, and trying to protect yourself is not parental alienation. The court is filled with not only male figures, but mothers of sons who somehow have a chip on their shoulder trying to protect their little boys from a fictitious imaginary thing that happened, or whatever the hell is going on. So then statistically, you have an incredibly low approval rate for EIOs, and the few that are approved, the majority are overturned. Many of you know my experience, but also I know people who have had a pew pointing at them and got the EIO, and then it was overturned within the 21 days that the perpetrator has the opportunity to appeal. Reversing all protections on mother and children, reversing the exclusive property possession order, occupation order, etc. Sorry, not possession order, occupation order. Further, adjudicators don't understand the weaponization of property and children. They don't. The vast majority don't. And when you bring it up in your hearing to show that this person is triangulating other things to control and violate you and commit violence on you, they then tell you that it's a civil matter, when it's not. You're trying to demonstrate why you need exclusive occupation, and then they turn it against you, saying that you're trying to solve outside of the courtroom for family court this thing with. No, that's not what's happening. Nobody goes and applies in full terror, wasting an entire day applying for these things and sit through the humiliation of it all and the trauma and re-traumatization of it all in order to just bypass family court, which you have to do regardless, because these things have a deadline. These things have a deadline. They only last for so long. Oh, but Mo, police have the discretion to implement safeties if they want. They don't. They can't be bothered. And many of them don't know the law. Many of them don't even know about the new updated bills that just passed, let alone the bills passed in 2016. I've read the law on Justice Canada website to officers because they didn't know the laws in terms of criminal harassment, interception of private communication, like any of those things. They don't know the law. They don't know it. They don't know the updates. They don't know the amendments that now include online stalking, etc. They don't. And so unfortunately, we have to know the law better than they do. And we have to know where to find these sources and show it to them. And we have to be willing to escalate to their supervisors, the sergeants, the staff sergeants, etc. We have to be willing to put in CRCC complaints. We have to be willing to push and push and push so that we avoid getting exterminated by the actual predator that groomed us and continues to pursue us while we wait for the Crown prosecutors to make a decision on a file that we also had to push to get to the Crown prosecution. And many of these cases are extremely violent. But officers say it's a domestic civil matter on every aspect of them, including rapes, including going through your phone without your permission, including all of these things, which are all criminal offenses. But this is the vulnerability. This is where New Brunswick is failing domestic violence victims, among many other places. But this is where we actually get unalived. This is where we get murdered. Do you feel the discomfort yet? And more importantly, what are you going to do about it?